Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. Although the PSC regime was only introduced earlier this year, it is now set to change again. The regime, which requires companies to maintain a register of people with significant control and to provide the register to Companies House annually, does not meet the requirements of 4MLD. 4MLD, which is due to take effect from the 26th of June 2017, will require the information to be held at Companies House on a real-time basis rather than being updated annually. It also widens the scope of entities caught by the disclosure requirement. More alarmingly, there is discussion about bringing forward the implementation of 4MLD to January 2017. The recent case of Barker v Baxendale Walker Solicitors of 2016 has given some helpful explanation on the limits of a professional's duty to advise. In this case, Baxendale Walker, an acknowledged tax expert, gave some advice concerning a complex tax avoidance scheme to his client, Mr. Barker. Unfortunately, the HMRC challenged the scheme and presented Mr. Barker with an 11 million tax bill. Mr. Barker then issued a negligence claim against Mr. Baxendale Walker. The court determined that the lawyer is only likely to be expected to warn a client that their advice might be wrong if there are very strong factors suggesting an alternative construction of the law. This criteria was not met in this case, as there was nothing to strongly suggest the advice was wrong until the HMRC challenged it. The court did, however, state that Mr. Baxendale Walker should have given a more general warning. This was a tax avoidance scheme, so it was always likely to be subject to a challenge, and that should have been made clear to his client. We have previously reported on cases such as MWB Business Exchange Centres v Rock Advertising of 2016, where, despite express anti-variation clauses, the contracts had been varied by conduct or verbally. The recent case of ZVI Construction v the University of Notre Dame follows this trend. In this case, the parties used an expert dispute resolution process. Whilst no one objected at the time, the losing party subsequently challenged the decision on the basis that the process was not permitted by the terms of the contract and that deviations were only allowed if they had been agreed in writing. The court held that the contract had been varied by the parties' conduct and that the courts will not restrict contracting parties regardless of anti-variation clauses where it is clear that they intended to vary the terms of the contract. The Information Commissioner's Office, the ICO, has issued a new code of practice for privacy notices, and this is available on the ICO's website. The code is designed to help businesses comply with existing data protection laws and the General Data Protection Regulation that will be law from the 25th of May 2018. The code recommends the use of innovative technology such as video to make privacy notices easier to use. It warns against the use of pre-ticked boxes for direct marketing and advises that consumers should be given the choice for their preferred communication method. The ASA has published guidance on the issues of offence and bad taste in advertisements. The UK Non-Broadcast Code and Broadcast Code contain clear rules that advertisements should not cause offence. However, it is not always easy to tell where the line is to be drawn, and the ASA guidance seeks to provide some pointers on the grey areas. The guidance can be found on the ASA and CAP websites. When services are transferred from one provider to another provider, the dedicated employees will have the right under TUPE law to transfer to the new provider, assuming the other conditions are satisfied, where the services are fundamentally the same. In the recent case of Salvation Army Trustee Company v Bahi, there were some differences in the services to be provided after transfer, and a dispute arose as to whether TUPE was applicable. In this case, the Tribunal and the Employment Appeal Tribunal, the EAT, determined that although there were differences, TUPE still applied. The EAT agreed with the Tribunal that to determine whether the activities were fundamentally the same, it was correct to ask what were the fundamental differences rather than asking whether the roles were fundamentally the same. It added that activities should be defined in a common sense and pragmatic way. We have finally had the Court of Appeal decision in the British Gas and Lot case. This has been the lead case concerning whether employees are entitled to average commission during holiday periods. It's an important decision as many similar cases have been on hold pending its decision, and many other companies have been treading water waiting for the outcome to determine how they will handle holiday pay. Now, whilst Mr. Lott was successful, the court was clear that the decision is fact-specific, so decisions in other cases may be different, but it would not decide how average commission was calculated. That part has been remitted to the tribunal. Other types of payments would require separate consideration by the courts, and was clear that the wording implied into UK legislation by the tribunal had been expressed too widely. It referred to all types of commission rather than just contractual results-based commission, as was the case with the British Gas matter. Now, whilst the uncertainty left by this case may be considered by some to be unhelpful, it does provide more opportunity for employers to challenge holiday pay claims. In a case that is reminiscent of the famous 1960s Ford Dagenham case, an employment tribunal has ruled that lower paid women working in Asda stores can compare themselves to higher paid men who work in Asda's distribution centres. Now, as this decision is likely to lead to the largest ever private sector equal pay claim, it will inevitably be subject to appeals. We'll keep watching this space with interest. 2 members of EasyJet's cabin crew have successfully argued that their employer's failure to limit their duty days to 8 hours to allow them to express milk or to offer them ground duties for an unlimited period of time whilst they continue to breastfeed was indirect sex discrimination. In April last year, shared parental leave was implemented. Now, to recap, SPL does not replace existing maternity and adoption leave rights, but enables mothers and adopters to elect to share up to 50 weeks leave and 37 weeks pay with the other parent. The default position in relation to statutory shared parental pay is that it is paid at the flat statutory rate. Employers may offer more generous enhanced arrangements if they wish, but the enhancements must be provided to all parents. In the recent Network Rail case, a father was awarded £30,000 for sex discrimination after only being offered statutory pay during shared parental leave, while mothers were given full pay for the first 26 weeks. It has already been confirmed that operators of online marketplaces, such as eBay, have obligations to prevent sellers using their service from infringing third-party intellectual property rights. The recent decision of the Court of Justice of the European Union, the CJEU, in Tommy Hilfiger versus Data Center, has extended this principle to offline marketplaces too, and permits brand owners to seek injunctions against landlords in such cases. It will not, however, be possible to claim damages from the landlords. The question still to be determined is who should bear the cost of complying with the injunctions. For online cases, the English Court of Appeal has ruled that whilst the brand owners must pay the cost of a court action, internet service providers must bear the cost of blocking the online infringers. We assume the same logic will be applied for the offline world. Specsavers seem to have achieved the impossible with its recent trademark registration for should've in relation to a range of goods and services. Now, trademarks will not normally be registered unless the mark is capable of being able to distinguish one entity's goods and services from those of another. It is therefore highly unusual for a company to successfully register generic words. Nevertheless, Specsavers were able to evidence that the public do associate this word with its brand. As we have previously reported, major prosecutions under the UK Bribery Act 2010, UKBA, now seem to have gathered pace, and we understand that the Serious Fraud Office has a pipeline of pending cases. One of the most significant features of the UKBA is the Section 7 strict liability corporate offence, under which companies will be criminally liable for bribery by their agents, representatives and employees unless they can demonstrate that they have adequate procedures in place to prevent bribery. In response to this requirement, ISO is now producing a new standard, the ISO 37001 Anti-Bribery Management Systems. In the event of a prosecution, companies that have implemented this standard will be better placed to defend a prosecution and evidence that they have adequate procedures. ISO say that the standard is flexible so that it can work for all companies regardless of sector or size. The draft ISO 37001 can be viewed on the ISO website. We've already reported in this bulletin that the ICO expects businesses to improve their communications concerning privacy notices. The Financial Conduct Authority is also asking businesses to improve their communications to consumers and has launched its Smarter Consumer Communications initiative. The feedback statement, which reports on the themes arising from the responses to its discussion paper on smarter consumer communications, sets out the FCA's planned work. Thank you for joining us for this month's commercial bulletin. The website details of Radius Law and LexisNexis will be shown on your screen in a moment. Please feel free to contact me if you would like more information on any of the topics covered, and if you've not already done so, you can get access to more content with Lexis PSL. Please don't hesitate to contact my colleagues at LexisNexis to request a free trial. Any other feedback on our bulletins is, of course, also welcome. We'll be back next month with another update. Until then, thank you and goodbye.